Welcome to another episode of Lawyers for Immigrants with your host, Yifei He, president of the Law Office of Yifei He, where they are dedicated to helping immigrants and new Americans. In every episode, Yifei interviews attorneys across different practice areas and asks them how they are helping immigrants. You can find this show on YouTube, LinkedIn, Apple Podcasts, Google Podcasts, Stitcher, Spotify, and at www.yifeiheelaw.com. Now here's the host of Lawyers for Immigrants, Yifei He.
Hello, and welcome to another episode of Lawyers for Immigrants. My name is Yifei He. I'm the president of the Law Office of Yifei He, where we're dedicated to helping immigrants and new Americans. Today, my guest on this show is Alex Sakin. Alex is an employment and business dispute attorney who I've known since BNI, which is a Business Network International. So Alex, welcome to the show.
Thank you, Yifei. Glad to be here.
Thank you. So Alex, tell us a bit about yourself.
Sure. I'm an immigrant myself, just like you, Yifei. I came from Russia in 1990, a while ago, and I started my legal career 15 years ago at Latham & Watkins, which is a big firm, a big international firm, and I worked in their Manhattan offices. After Latham, I worked at a boutique firm, a very well-regarded boutique firm, also in Manhattan. And then I was a prosecutor in New Jersey, and ever since 2017, so for the past 5 years, I've been the president and managing partner of my own law firm, the Law Office of Alexander Sakin, LLC, where we specialize in employment law and business disputes, and primarily on the litigation side, although we also counsel businesses and individuals in these areas of law.
Excellent. So what inspired you to become an employment attorney?
Employment law is incredibly important. The thing about employment in general is that it's something that you spend much of your day doing, is working. And employment becomes, especially in our country, I think, essential to people's conception of themselves and their sense of self-worth and value. They attach a great deal to it. And so when anything that happens that's employment related, therefore, is important to people. And I want it to be in an area of law that touches upon things that are important to people and that really affects everybody. I think that if you work long enough and you spend enough years either as an employee or as an employer, you will come into contact with employment law. You will, whether you like it or not, you will have to learn something about employment law. And so I liked, and I enjoy practicing an area of law that is so all-encompassing and that applies to everybody. I meet all sorts of people. I've represented all sorts of individuals and all sorts of businesses, from small businesses to large businesses, from executives to low-level employees, and it never ceases to be interesting.
That's very interesting, Alex. So tell me more about your employer side practice in employment law.
Well, employer side practice consists of representing businesses either with respect to the drafting, let's say, of employment agreements or handbooks, or making sure businesses comply with various regulations, the myriad regulations that apply to any business, from federal to New York State to New York City. And that's one area of my practice, is compliance oriented. And then another area of my practice is representing businesses in litigation. And that litigation can take place in court. It can take place in federal court. It can take place in state court. Or it can also take place before various agencies that are empowered to enforce employment laws, such as the EEOC, the Federal Equal Employment Opportunity Commission, or the New York State Division of Human Rights, or the New York City Commission on Human Rights, And finally, before arbitral bodies, there are also private arbitrations, private disputes that take place where I will represent employers.
I see. So it's very important to know the laws if you have a business in New York. Is that right?
I would say that when a business hires employees, it's kind of a game changer for that business. From a legal perspective, it's a game changer. All of a sudden, that business becomes subject to all sorts of laws that it better be aware of, unless it's before it becomes too late. When you're hiring employees, you need to be aware both of laws that apply to the hiring of an employee, the termination of an employee, laws that apply to the actual employment, how you treat employees, how do you pay employees, how do you give them time off, how do you accommodate or not their disabilities, all sorts of things you got to keep in mind, because there are hundreds and thousands of employment lawyers in the city and around the country that are more than happy to take on cases. The plaintiff side of the employment bar, so that is attorneys who represent employees in litigation. Many of them are paid on contingency, so they only collect if the employee collects something in litigation. And so as a result, it's quite easy for an aggrieved employee to hire an attorney who will represent them and who will make trouble for you as the employer.
Right, definitely. So it's very important. And as the name of the show implies, we're lawyers for immigrants. So I was wondering, do you have any advice for immigrant business owners or international business owners?
Yes, of course. So those types of businesses have specific challenges that other businesses may not face. I mean, I'm thinking of businesses that are located in sort of ethnic enclaves in the city. We have a bunch of those, and that cater the businesses that cater to certain communities because of cultural affinity, because of linguistic affinity, and so on. Those types of businesses have special problems, primarily, well, to begin with, in terms of hiring employees. Those types of neighborhoods in which those businesses draw their employees tend to have a lot of undocumented workers, undocumented people, and it becomes a challenge at times to properly document your employees. And that's something that those businesses have to think about, have to watch out for more than others. Now, in terms of other issues, is that oftentimes I find that those businesses want to draw because of various cultural affinities, like we discussed, from certain groups when they hire employees, and that can actually result in discrimination claims. Let's say you're a Chinese business, just to pick on one community, and you have most of your customers or clients are Chinese, and you want to have staff that speaks Chinese. Well, you have to be careful in how you hire employees, and you have to be careful in making sure that you're not, let's say, putting in your employment ads that only Chinese speakers need apply, or that you're turning away people who are not of your ethnic or linguistic background. It's certainly something you have to watch out for.
Right. I mean, let's break that down a little bit. So first, when you're hiring employees, it's important to have employees who are authorized to work. Is that right?
That's right. But at the same time, it's tricky because you should be hiring people who are authorized to work. I mean, you'd be in violation of all sorts of laws if you were to hire people who are just blatantly undocumented. At the same time, you should not be discriminating based on national origin, and you should not be discriminating based on immigration status, and there's quite a bit of overlap. So, the advice I give always to businesses is that the way to not run afoul of that of these two sets of laws. On the one hand, immigration laws, and on the other hand, anti-discrimination laws, is not to ask questions about documentation or status at all during the interview process. Not to specify anything in the ad, in the employment ad, and never raise this issue. Rather, it's the way to go about it correctly without running afoul of the law is to interview the person. If you like the person and you want to hire them, you give them a conditional offer of employment that is subject to them providing you with documentation, proper documentation that is found in this form I-9. And if you ever worked, you know what I'm talking about, because if you had to bring those forms on your first day of work, and there's a reason why you bring them on your first day of work. It's because these are not the types of questions that you should be asking as an employer before the offer is extended. When you're interviewing a person, you should be first and foremost thinking of their credentials, not of their national origin or of their immigration status. Now, if on the first day of work they don't bring the required documentation, or the documentation they bring is obviously not authentic, then you're allowed to not extend them the offer. Actually, not allowed. You're required not to extend them the offer, because then they may not be authorized to work in the U.S., but not until then. And the problem that occurs in these communities is that oftentimes the employers who are not being advised by an employment attorney will ask those illegal questions during the interview, sense that the person is not documented, and then just stop the interview or not even extend an offer. And then that person who didn't get the job will either sue them or complain about them or raise other trouble for them.
I see. And as an immigration lawyer, it's not very black and white sometimes someone's ability to work, because they might not be citizens, for example, but they can either have a green card or not even a green card. They can have a work authorization.
Right.
That puts them on the same footing as someone who is a citizen in terms of being able to work for that person for I-9 purposes. So it's important not to discriminate against in the hiring stage.
That's right.
But let's move beyond the hiring stage. What happens if, say, it's a ethnic business and their clientele is mostly their same ethnicity? So how do you hire someone? How do you structure a hiring post so that you attract the right candidates versus someone who won't be able to serve the clientele of that business?
I find that, as a general matter, those types of businesses don't actually. It's something that becomes organic, somewhat organic, and oftentimes it is organic. The people who apply kind of know what they're getting into, and you don't have to explain it too much. But at the same time, you do have to be careful in the kinds of questions that are asked and the kinds of considerations that are extended. There's nothing wrong with requiring a fluency in a particular language, especially if that's if that's important to the clientele, right? The national origin is the problem. If you're discriminating based on national origin, then that's a problem. But there's nothing wrong with expecting fluency in a particular language, because if you're a medical office, let's say, and you have a lot of elderly Russian patients who don't speak English, well, you may need somebody who speaks Russian to them. That's communication. Right. Verbal communication is an essential part of the medical of any medical job, and so you may need somebody who's fluent in Russian.
I see. Okay, well, let's move on to the more fundamental aspects of a job, the actual getting paid. Most people, especially in the service industry, like the restaurant industry, they're paid hourly. So, for example, someone who's working at a restaurant in a Chinese restaurant, for example, the cultural norm might be to be working more hours than is expected, not just 9 to 5, but to please the boss, might be working overtime.
Right.
And get them into trouble. So how can small businesses, ethnic businesses, avoid these troubles?
Wage and hour laws are actually some of the most draconian. And I think one of the most serious problems that a business can have from an employment law perspective is our wage and hour problems.
Right.
Just because the penalties are can be very, very draconian, very serious, and those cases can be quite black and white. A discrimination case, if you're the plaintiff, well, you have to prove certain things. You have a burden of proof, and it can be quite hard actually to prove discrimination oftentimes. But if you're not paid properly, you're not paid properly. And at times it can become very black and white. And actually, as somebody who represents businesses in wage and hour disputes, it can be a very thankless task for me at times, because I find myself telling my client, well, you should have come to me earlier. You should have come to me when you were setting up your payment system. Now that you're being sued, there's only that much we can do, right? Like, you have records, you have the time records, you have the canceled checks, and they show what they show. And I'm sorry, but you're in violation of the law. The first thing that any business that has hourly employees, or even a business that does not have hourly employees, should be doing is tracking hours. It's very important to track and keep track of employee hours. And there are all kinds of ways you can do that. You can do that through an electronic system. You can do that by having an old school sign in, sign out sheet. You can have a computer where they have to log in. However you do it, you should always keep track of employee hours. If you don't keep track of employee hours, what happens is, if the employee sues and claims, let's say, that they were not paid for certain hours worked, then under the law, and there are no records, right? So the employee sues, there are no time records. Under the law, the employee's memory of hours worked will be sort of presumptively deemed correct. Okay, so whatever the employee remembers will be presumptively deemed correct. Now, you can still disprove it, but it's much harder at that point. To avoid that, you need to keep track of hours, and that's really the first and foremost thing. Secondly, of course, you should be paying, if the person is entitled to overtime, they should be paid time and a half. They should be paid overtime for any hours worked over 40 in a week. That's how in New York you measure overtime. It's over 40 in a week. So those are the two most important pieces of advice I can give on wage and hour laws.
I see. Well, it's very important, because some employers, they might not be in the understanding, or they might not understand the importance of laws and keeping track. Here in the U.S., they might have something sort of like more of a trust basis. So it's important to follow Alex's advice and keep abreast of the laws and document everything, because as an employer, you have to protect yourself. You're not going to be protected otherwise. So
right. Exactly. No, otherwise and then what happens is that, look, it's never an issue, and then you fire the person.
Mm-hmm.
And then they go to an employment lawyer, and the employment lawyer tells them, well, you know what? Actually, you don't have a great. Sorry, just let me silence my device here. Actually, you don't have a good discrimination case. Your discrimination case is not great. But what you do have is a great wage and hour case.
Right.
Okay. And that becomes a problem. So sometimes you'll have a client who comes to me on the plaintiff side. A client will come to me and claim, well, I was wrongfully fired, or that's what they say. And then you start speaking to them and you ask, well, how are you compensated? How did your employer pay you? And it turns out that that's really where the big bucks are. It's not in the discrimination alleged. It's in wage and hour. And it opens up a whole can of worms.
Okay. Well, I mean, is the presumption to just pay wage and hour then, like hourly, instead, so that you can like properly document everything, versus having a salary, because then they might be working overtime and you don't know it.
Well, salary is different. I mean, so under the law, everybody is entitled to overtime unless you are exempt from the overtime laws. Okay,
Or,
and you are exempt if you satisfy various tests, and that's something you should speak to an employment law specialist about, because certain employees will be exempt and certain employees will not be exempt. Generally speaking, this is very crudely speaking, the higher level employees tend to be exempt. Not all though, but generally speaking, that's how it works. And the lower level employees are not exempt. But
okay.
to determine whether they're exempt or not, it's best to speak to an employment law specialist, because those laws are complicated and it can be quite subjective.
I see. All right, so we've gone through the hiring process. We've gone through the actual hours that employers should comply with. What about the final stage when you have to let someone go? How can employers prevent getting sued for wrongful termination or not giving enough notice for firing people?
The only way you can really prevent an anti or a lawsuit based on one of the anti-discrimination laws is to obtain a release from the client, a release of claims. That release of claims, to be valid, has to be in exchange for something. It's usually in exchange for money. So some companies have a practice of everybody who's fired for any reason, unless it's something really egregious, gets severance. Okay, so they're paid severance in exchange for a release, for signing a release, and that releases the company from liability for any type of discriminatory behavior. Now, there's a wrinkle to that, which is, even if a person signs a release, they can still go to one of the agencies, the human rights agencies, the EEOC, the New York State or New York City human rights agencies. They can still complain about you, but they cannot. But if they get a release, they cannot sue you in court. And a lawsuit is probably the worst thing that can happen when it comes to liability for discrimination.
I see. So what happens if somebody complains about you before one of the agencies? Do you get what do you get in terms of punishment?
Well, look, the agencies are well. First of all, they're not those types of investigations are not they're not public, unlike court. All right, so there's less exposure. There's less. It's not as embarrassing for the for the employer, right? But they also take a long time. Unlike court, it moves, the agency process, the investigation moves very, very slowly. Okay. Now, in terms of what the penalties are, well, they could really add up if you're found liable. The employee could get back pay. So the money that person would have made had he been not fired for, let's say, a year or two. They can obtain emotional distress damages. They can have their attorney's fees paid. You could be looking at six-figure liability easily for firing somebody on an improper ground.
I'm talking about, what if someone has a release though? Like if they have a release of damages and someone goes to an agency, right, what can the agency do?
Usually,
were these same things?
Yes, they can still do that, but the usually whatever you're paid. Well, the thing is, so first of all, it's very rare, very, very rare for somebody to file a complaint with an agency after signing a release. Just psychologically speaking, it's something that people who sign releases and obtain severance don't do. And I've seen it happen, but it's rare. So it still is worth your time to obtain a release in exchange for severance. It absolutely makes sense as a business decision. If they do go to an agency and they prevail, which is a big if, then usually whatever you paid to them as part of the severance is subtracted from whatever they may obtain from the agency. But again, that's a pretty rare scenario. It's happened. I've seen it, but it's not something you see every day, where somebody goes to an agency even after signing a release. it's still better to obtain the release because at least they can't sue you in court.
I see. Okay, that makes a lot of sense because, as I mentioned, immigrant business owners or small business owners wouldn't think of that. They wouldn't have a policy of making employees who get terminated signing them releases.
Right.
They're not aware that they have to protect themselves. So it's a good thing that someone...
They may think it's a waste of money, and I don't think it's a waste of money. I mean, I think it makes sense. And I think it also softens the blow. I think it's psychologically, look, being fired is not pleasant. But if you're at least paid severance, I think it softens the blow, and I think it makes people less angry. And in that situation where you're firing somebody, it's very important to limit the anger. Make it as pleasant, and I mean, it's not a pleasant experience inherently, but I guess as painless as possible. And one way to do that is to offer severance.
Right. Well, definitely, I think what you're providing to our listeners is a valuable resource. Would you like to conclude this show by adding anything else that you think would be helpful to small business owners, immigrant business owners, or international business owners?
I think, I think you should always have an employment law specialist on call or available to speak to if you're and the times to call an employment lawyer are when you are hiring an employee, if you're firing an employee, if you are disciplining an employee, or if somebody is threatening to sue you or suing you. Those are the times you should really be speaking to an employment law specialist. And also, I should also add, anytime you're dealing with an employee who has disabilities or serious sicknesses that prevent that employee from working, those are all sort of moments when you really should be speaking to employment law specialists, because you may have to spend money on that, but you'll spend a lot more if you get it wrong.
Right. And I encourage all our listeners to reach out to Alex Sakin. He's an employment attorney. He counsels small businesses, immigrant businesses, and international businesses. And we met first on BNI, which is Business Networking International. And as part of our weekly meetings, we would present every single time. And Alex would only present very interesting material about employment law, current trends, topics that are important for business owners. So I encourage everyone to reach out to Alex. He's a great resource. And
Thank you.
He can be your counsel. So again, thank you very much, Alex, for appearing on this show.
Thank you. Have a good one.
You've been listening to Lawyers for Immigrants with your host, Yifei He. You can find prior episodes on YouTube, LinkedIn, Apple Podcasts, Google Podcasts, Stitcher, Spotify, and at www.yifeihelaw.com. Thank you for your positive reviews, comments, and sharing this show with others.